Good morning, Your Honor. May it please the Court, my name is Michael Schneider, and I represent the defendant Alex Filopoulos, and with me is Attorney Ryan Schiff. This case gives this Court a first opportunity to take a close look at the child enticement statute, Chapter 265, Section 26B, which became effective in 2003. The statute punishes anyone who entices either a child under the age of 16 or someone he believes to be a child under the age of 16 with the intent that he or another violate one of 18 listed statutes or offenses that involve the use or attempted use of force.
And your position is that there has to be a showing that the defendant had specific knowledge of the age of the victim.
Yes, that's correct. It's our position that that is what the statute says, that is what a plain reading of the statute says. If you look at the statute, I mean, it specifically says, with the intent that he violate one of 18 statutes. And if you, we've cited to Webster's Third International Dictionary with respect to the meaning of the word violate. It generally involves to break or disregard in the case of a law, a specific law. We would suggest that legally, when this kind of language has come before other courts, such as the Supreme Court in the cheat case, a tax case, the court has essentially said that an intent to violate a law involves an intentional violation of a known legal duty.
But how about this? There's a crime, assault with intent to commit statutory rape.
Correct.
Assault with intent to, but there's no requirement to prove in that case, is there, that the defendant knew that the person was underage?
Well, this is a very different statute. First of all, it's drafted differently, which is what this Court, after all, should be most concerned with, effectuating the legislative intent as manifested by the language. But in addition, this case involves expression and that is and conduct that is really quite different than the kind of assaultive conduct.
Well, you have assault with intent, you have assault with intent, you have enticement with intent. Why are they different?
Well,
why does one?
In that context, it's my understanding that the assault with intent to rape a child under the age, the knowledge of age actually is a requirement.
Well, I don't.
I may be wrong about that.
I don't see that.
I'm not entirely certain.
I think that's quite the contrary.
You can check it and get back to us.
But let me just say that there is a huge difference here when you're dealing with enticement as opposed to dealing with an assault. When you're dealing with an assault, when you're dealing with rape of a child, when you're dealing with indecent assault and battery of a child under the age, you're dealing with what has to be face-to-face conduct, where the courts have historically recognized, and the Commonwealth is correct about this, going back more than 5 centuries, that a person in that circumstance essentially assumes the risk. You're in a position where you know that you are taking a chance. The problem with this statute, and here that we're kind of getting more into the potential overbreadth problem here, but the problem with this statute, if you read it the way the Commonwealth says, is that it would actually punish those who simply innocently intend to have sex with another.
Why is this statute overbroad if the underlying statutes are not overbroad? It seems to me that this statute is just ancillary to the other statutes, and the only way it can be overbroad is if the underlying ones are overbroad.
Well, I don't think that that's necessarily true. The issue with respect to any given statute is whether the statute itself as interpreted is overbroad. And I just don't think that syllogism actually works as a matter of logic.
Well, look at the drug zone cases. Yeah. Why is it any different, this statute any different from the school zone cases, school zone statutes? From the underlying statutes, the defendant knows what he's not supposed to do, and the school zone is really just a sentencing enhancement. It's added on. But
in those cases, we're really dealing with vagueness over breadth, and in this case, we're dealing with First Amendment over breadth. And I would suggest that the reason why this statute is overbroad is for the exact same reasons that the Supreme Court very clearly articulated in Reno versus ACLU.
Explain that. How Reno versus ACLU bears on this case.
Well, in both cases, the statute covers the putting out, the sending, the articulating of a seductive here or indecent there
So
messages.
Reno involved a statute in relating to the dissemination of obscene materials.
Well, no, in
over
that
the
case, it was
Internet.
not obscene materials.
Patently
it was
obscene
indecent or
materials.
patently offensive materials.
excuse me,
It was
patently offensive
Well, that's
materials.
important because it was protected
Okay.
speech. It was protected indecent or offensive speech as opposed to speech that is actually prescribable under the obscenity doctrine. So in this case, it's the sending out of a seductive or indecent message. In this case, a message manifesting simply an intent to have sex or sexually touch another. In this case, it would cover, because there's no medium listed in Section 26B, it would cover Internet and other forms of non-face-to-face forms of communication.
I'm intrigued by this face-to-face thing because we have had cases all across the country where there has been face-to-face contact, and we've had even more than face-to-face contact where the child represented his or her age to be greater than 16, 18, 25, something like that. And even if you look at the child, you see somebody who certainly doesn't appear to be under 16. So I'm not so sure what the face-to-face aspect, how that helps you.
I mean, I think historically it probably was behind the common law thinking that developed the basically the strict liability rule. But I think in the context of a face-to-face communication, which inevitably happens in an assault or a rape, you're in a position where you're taking your chances, you're assuming the risk, you're dealing with, you're in a position where you know you're not dealing with a 50-year-old woman.
This was face-to-face here. They had this girl in the back of the car, in the front of the car. They had her somewhere. Why isn't this like statutory rape?
Well,
Where
first
if
of all,
the rape occurs, you can't, there's no defense. Oh, geez, I thought she was over 16.
I should make it clear that this is what our claim is, that if you give the statute the kind of construction that Judge Lowy did and that the Commonwealth did, you will have in a fairly large number of cases, you will have the exact same
Well,
kind
maybe
of
we don't
overgrowth
have to give
problems.
that construction. Maybe we just limit it to the facts of this case, and we leave the rest of this Internet and all this other stuff for another day.
Except that in this case, the first issue was very clearly preserved, how to construe the statute as drafted.
On these
Did not
facts.
object, on these facts, well, the defendant did not object to the judge's instructions. The Commonwealth concedes that the issue was about the statutory language and its meaning, that issue was squarely preserved.
Well, to what extent? For purposes of a facial challenge or for purposes of an as-applied challenge?
The issue as to whether or not the judge gave a correct jury instruction when he said that the defendant need not prove, that the Commonwealth need not prove that the defendant was aware that the victim was underage, that all the Commonwealth needed to prove with respect to Section 13B and Section 23 was that the defendant intended to have sex or sexual contact, and that, as a matter of fact, including unbeknownst to the defendant, the victim was under the age of 16.
So aren't you limited on this appeal to an as-applied challenge?
We are. I will concede that we do not have a formal overbreadth challenge to the extent that this Court does not believe that issue was adequately preserved by the defense counsel's motion to dismiss. And I would have to concede that defense counsel's motion to dismiss does not mention First Amendment or Article 16. It does not mention overbreadth. It talks about the expansive application of this new statute, and it does make reference to the fact that this has applicability in the computer world, in the Internet world. But I could certainly understand how this Court might decide that overbreadth issue was not squarely raised, even though at least it was brought in some manner to the Court's attention.
Was it raised again in the charge conference?
No.
That issue was not, no. That issue was never again, that issue was never again raised. But the overbreadth
So
issue
you've got a straight-out, as-applied challenge. So why isn't it like statutory rape?
Well,
Here and the girl was there, she testified, correct?
correct. Because the problem is that this will run into an overbreadth challenge. This will run into an overbreadth problem.
We'll deal with it when we run into it.
But at this point, Your Honor, the court is in a position of having to actually interpret the statute. And there is a general principle that the court should interpret a statute to avoid any kind of identified constitutional problems.
Why is it necessarily unconstitutional for the legislature even to, if the Internet is included here, even though there could be innocent types of behavior, there's enough criminality involved that the legitimate caller assumes the risk of communicating with someone underage. I mean, the legislature perhaps could rationally conclude that these types of Internet communications are fraught with peril. It isn't just a communication, but it's an invitation to go someplace. And if that regulation exposes someone with innocent motives to criminality for contracting with somebody underage, why is that necessarily impermissible?
I would suggest that the kind of messages, the kind of utterances that are covered by this statute cover a tremendous array of territory, from some fairly pretty offensive and indecent, come over here and do this to me, to very sublime forms of wooing and courting. And I would suggest that in this day and age, certainly in light of the Supreme Court's decisions such as Lawrence v. Texas, that the courts have come to recognize, the Supreme Court has come to recognize, this court certainly recognized, that areas involving intimate personal relations and matters pertaining to sex are indeed things that are well beyond second-class status.
What's so intimate about something that goes out over the Internet?
Between consenting adults.
What's so intimate about...
Well, catch a predator.
Have I seen it?
Yeah.
Unfortunately, yes.
They have these statutes all over the place, and these guys are Internet guys, and they're caught. And they're in Kansas, Florida,
Well, I
So
would
these
point-
statutes are, not uncommon.
Right, and there is a federal statute that we've cited. I think it's 18 U.S.C. Section 2422. That statute specifically has a knowledge of age requirement, and several courts that have looked at it, including the Meek case, which I cite in the brief, and the Panfill case, which the Commonwealth cites, Ninth Circuit and 11th Circuit, both of those courts have upheld...
That's not helping the guys that are caught on this show, because they're prosecuted under state statutes, and not one of them can say, oh, gee whiz, I thought she was 25.
The question is whether juries in those cases would need to be charged that the defendant
Yeah, which leads, of course, to the question is what is the law else?
Actual knowledge of age, yeah.
Do we have law from other states on this?
I
Did
did
anybody
cite
look?
the one state statute that I did cite in the brief is a Michigan statute, and to be honest, I just don't recall what it what it provides for.
And you couldn't find anything beyond Michigan?
I didn't find anything.
Well, is this statute sort of the one we have here, Section 26D, patterned after some uniform national statute? I mean, is this wording occurs in many states?
If it is, the American Law Institute has done a pretty poor job of thinking through a carefully worded statute.
So you mean this is a homegrown statute?
I believe, my understanding is that this was a homegrown statute that was, fairly quickly patched together. I do think that the language, though, that the legislature knew full well what it meant when it wrote the words intent that he will violate one of the specific statutes.
Mr. Schneider, may I ask you this? If I look at the language under subparagraph B, first sentence, there's an or in there. So if I'm trying to look at the legislative intent, anyone who entices a child under the age of 16 or someone he believes to be a child under the age of 16.
Certainly.
Now, does that mean that if he entices a 20-year-old, but the Commonwealth can somehow prove that he actually thought the 20-year-old was a 16-year-old? I don't think that's what the legislature...
No, I think the legislature included the language after the or to permit...
Sting operations.
Sting operations.
Yeah.
That was the purpose of that provision.
So an officer goes on the internet and says, I'm looking for somebody under 16, or I'm under 16.
I'm under
looking
16
for
too.
Right.
No, I understand that, but that means whatever use the government wants to make of it, there's still two provisions, and who entices a child, you can almost read, who is under the age. In other words, whatever the circumstances where you believe the child is underage, the government has to prove that, right?
Correct.
But you've got the first piece, which simply says when the child is under the age.
Well, I would suggest that the only purpose of that provision is to allow for sting operations, where the person, a defendant may believe, a suspect may believe that the child is under the age, but is in fact not. That's the purpose of that, I would submit, of that provision. And I think it's fully consistent with what I would submit is really the plain language interpretation of the statute. I can see my time is up, so if I could just conclude, unless Your Honor has more.
And your time is up.
And my time is up. If I could just conclude with one final thought, which is that this Court, like the Supreme Court, has recognized that in order to protect our very important First Amendment and Article 16 rights, it is important to protect the unsavory as well as the sublime. And in this case, and it is particularly important to protect the unsavory in order to protect the sublime, and I would submit this Court should adhere to what I believe is the plain meaning reading of the statute and should reverse and remand for a new trial at which a correct instruction would be given. Thank you.
Thank you, Mr. Schneider. Mr. Steinfeld?
May it please the Court, Kenneth Steinfeld for the Commonwealth. I would first like to address Justice Cordy's concern earlier about whether the crime of assault with intent to rape, also known as attempted statutory rape, is in fact a strict liability crime. It was held in Commonwealth versus Dunn, 394 Mass 10 in 1985.
I've got it right here.
I just wanted to make sure. Secondly, I'd like to make what I think is a very important distinction that arose from some questions from Justices Spina and Graney about what is preserved and what is not preserved. There is no constitutional claim before the Court. The only claim that was brought below, that was argued very often, that there's no question is before the Court, is simply one of statutory construction, whether or not the legislature intended to prohibit the behavior that the defendant engaged in and whether they used language that effectuates that intention. There is no as-applied constitutional claim before the Court. The defendant did not argue below that the Constitution prohibited violating his behavior. He merely and solely argued that the statute didn't prohibit it. Now, he says that that is because the plain language of the statute requires that holding, and I would strongly disagree with that. I don't think the plain language of the statute really totally answers the question. I don't think there is any correct answer to the question, what does it mean to intend to violate a statute that provides penalties for a strict liability offense? I think you have to look to the rest of the statute and the purpose of the statute. I do admit that there is some draftsmanship in the statute that's imprecise, but I think that the intent of the legislature is absolutely unmistakable. And I say that.
Did you happen to look at other states at all? I
Yeah.
would imagine these are common statutes.
Yes. I actually, there's another case pending before this Court, Commonwealth versus Distler, which I intended to bring up later, because the overbreadth argument, that case presents a First Amendment challenge. This state statute is similar to many state statutes. Certain clauses and language are found. This was put together differently, but you can find the language in this statute in statutes of many other states. No other statute has the identical language altogether.
So have you given us those other states and how their courts have, what they've done with them?
Not in this case, no, because no statute has the same mix here of attempted with the intent to commit statutory rape. There's no statute that I could find that has the problem that the defendant has identified in this case.
Are the constitutional questions before us on the substantial risk standard?
I do not think so. As far as the overbreadth claim is concerned, I don't think this Court can do a substantial risk analysis, because the premise of an overbreadth claim is what I did is wrong, is prohibited, and they got me. However, there are others who are chilled whom this statute will harm because it will infringe on their First Amendment protection. So there's no question that there was not a substantial risk of a miscarriage of justice here because he concedes that he broke the law and that the law may prohibit what he did.
Well,
So-
it is fair.
He doesn't concede that he broke the law, correct? I mean, he concedes that he testified as to his view of the evidence. So he concedes it was him, he was in the car, he said certain things out the window, that a young person, a woman in an Anilac got into the car, that he, didn't look, to her. So he concedes in the sense that if it's strict liability, to incorporate a different term, there's no question.
Yes, but I'm talking about the premise for an overbreadth clause to begin with, separate from what he conceded at trial. To assert an overbreadth claim, you have to say, I broke the law, but the law will infringe the rights of so many others that I am entitled to have the law thrown out. So I agree that he did not concede at trial, I intended to have sexual intercourse with a person I knew to be underage. He definitely didn't do that.
Right.
But he cannot assert an overbreadth claim without saying first up as a basic premise that the law permissibly prohibits what he did.
Can I ask you this, though? I mean, whether or not the constitutional questions are before us, we certainly do interpret statutes. This is our first opportunity to interpret this statute. Constitutional questions have been raised. The Reno case gives us important pause. So we would want to interpret the statute to avoid constitutional problems. That's a fair statement, is it not?
Certainly.
How does Reno apply or not apply to this case?
Well, I argue that it does not apply because that case, as well as the Ashcroft case, one involves the Communications Decency Act, the other the Child Online Protection Act. Those, in the words of those courts, those statutes, in the words of the Supreme Court, those statutes unapologetically sweep within its prohibitions a huge amount of obviously protected and valid speech. That is simply not the case here. The type of speech involved is not the vast, broad array of speech.
Well, the type of speech involved is broadly enticement.
Yes,
And that's a broad range of speech.
but it's
It's
a
even,
communication.
isn't it even more broad when you actually look to lure, yes, induce, persuade? To persuade, that's an awful lot of conduct, to persuade, to tempt.
Certainly, but as the Panfield case says, and others, which is
Right.
a Circuit Court of Appeals case that I've cited. I'm sorry, I just lost my train of thought.
Why Reno? Why the
Right, but
Reno?
the specific question.
Well, enticement.
I'm sorry. 16 of the 18 crimes, the intent has to be to commit a crime against a child or a sex crime. So that takes it out of the First Amendment protected area because the intent is to commit a crime or a sex crime or an act of violence against a child. The problem only arises when the underlying crime is one of statutory rape or assault and battery. Indecent assault and battery on a child under 14. Those are the only cases in which there is no criminal intent to commit or specific criminal intent to commit an act. And statutory rape has, as this Court knows and as my brother concedes, it has never been a defense, either a mistake of fact, reasonable or not, or not being aware that the law prohibits what you have done. And I think this Court should not lightly engraft on the statute this requirement that has never been associated with the crime.
Could we view this as just making enticement a separate crime?
Of statutory rape?
It's a separate crime, enticement to do the following acts.
Sure, I think that is what the intention of the legislature was and what the Act actually does. The purpose of these of laws like this is to make it a crime before there is a real danger to the child, because these situations, enticement situations, involve by nature dangerous situations. So as soon as one can criminalize the behavior, the better off a child will be, the purported victim will be.
So you're suggesting that they were really aiming at the man who drives up in the street and calls out to some young girl on her way to school, but it's something, and then she runs away.
Yes.
That was the intent here.
I think
what
that's
they were
certainly
trying
covered.
to criminalize.
I do think they were more thinking about crimes on the Internet, but the language is certainly broad enough to encompass what I consider this case to be, which is classic, quintessential, almost cliche. A strange man pulls up in a car, says, "A little girl, would you like a ride? My father sent you," something like that. I certainly think that this is absolutely, they intended, the moment that he made that invitation, he committed the crime.
Are you saying that because the speech is unprotected, or are you saying that the state has a compelling interest?
Well, I think both is true. I think a lot of courts have held that there is no First Amendment right to sexually solicit a child. The authority for that is
Mr. Steinfeld, I take it that you would have no problem with the following. An adult going to what any reasonable person would think of as another adult site. In other words, it's not a high school site. It's the postgraduate listserv of, a university, and says, I'm interested in, meeting, people affiliated, for the purpose of engaging in fun.
People who? I'm sorry, Your Honor?
Who are on this listserv,
Right.
engaged in fun, frolic, and, all the nice New York Review of Books code words for, personal relationship.
Sure.
And then it turns out that when the person arrives, it's actually the, 15 and 11-month daughter of the postgraduate student. Postgraduate student.
So she's portrayed herself to be older than she actually is.
Well, she's on a listserv.
Right. Well, I think the same policy that has supported statutory rape law all these years applies to this as well. When the purpose of communication is to arrange a sexual liaison, the burden is on the person doing the arrangement.
So then she arrives.
Yes.
And because he's aware of the law, he says, I'd like to see your driver's license.
Sure.
And she shows him the driver's license. Well, she says, I don't have a driver's. Why don't you have a driver's license? Well, because I haven't bothered to, whatever, but he actually makes
the
the
attempt.
attempt.
We assume that his intent is to have some kind of sexual activity with her?
Yes.
Yes, but he also is a careful person, and before he does, he makes double sure she looks like a 22-year-old. This is not surprising. But he doesn't actually do anything. He doesn't touch her. He doesn't have any sexual relationships with her. He makes her, in a face-to-face meeting, prove that she's not 16.
He has already committed the crime pursuant to the statute, and I think the Constitution permits
That's the frightening
that
part.
to be criminal. Well, there are.
But that's
the overbreadth
very
part.
protected speech. That's very protected speech. Otherwise, you've got all these personal ads, and we've got huge businesses who make it. We're living in a world where apparently, the endless successful relationships, marriages, and otherwise online. And you're saying if you engage in that behavior, you have. Isn't that the problem? Committed the crime?
Yes, absolutely. I'm not saying that this court should never review this statute to see whether it's overbroad. I'm saying it definitely should not do so in this case.
Okay.
Because it was not. Oh, certainly there are many, many scenarios, and I spent the last 2
Well,
days thinking of.
that's your Catch the Predator show. The guys think they're dealing with someone who's over the age, proper age of consent, and then they get there and.
Jeez,
the
I thought
Predator
the episodes were different than
Shows
that.
the Predator shows. I've seen them all as part of my work. I actually tried to bill for the time, and it didn't work.
Well,
But,
a couple of them when they got
in
there.
all those cases, they go out of their way to make clear repeatedly that the child is underage.
Oh,
They
all
have
right.
they very often even have the purported age of the child within the screen name
Oh,
used. It'll
okay.
be
So
like,
we don't have to worry about that.
right. So in all those cases, they make absolutely clear that the person is underage.
Okay.
I mean, I recognize, and it's a perfectly fair position for the Commonwealth to take, that it wasn't raised here, it's not on these facts, you can run it on endlessly. Although, think of this, he says, as soon as I realized, or if you go back to my hypothetical, when I actually tried to focus on who it was that I'd enticed into the car, right, then I realized that she appeared to be underage, and I immediately stopped.
The law, I think, permissibly and properly shifts the timing of the burden. Make sure before you entice. It's the same with statutory
But that
rape.
would be no different in the Internet case that I mentioned, and that's the problem here.
Yes, yeah, but I think the law has always required that that before you engage in sexual activity with a stranger, that you ascertain with certainty how old that person is. Here,
Well, first I have
think
to
the same
ascertain
principle-
whether the person is in. I'm not going to go onto my listserv and say, I want to know your age. Everybody, who, you know.
Sure, there's definitely plenty of examples we all can think of in which behavior we would all consider legal, dating services, a child getting a credit
They are
card
legal.
and pretending. There's certainly all kinds of examples, but a statute should not be invalidated merely because we can think of one or two examples or even many examples, unless there's a fully developed record below when the claim has been asserted and hashed out. And there's evidence. We have no evidence before the court about any of these issues. The court can take judicial notice of a lot of things, but this sort of claim should only be reviewed when there's a record. And I would submit that there is a record in a case called Commonwealth v. Dissler, which is pending before this court, in which a First Amendment challenge has been squarely raised. So the time will come, and Dissler is one of those times, although the question is slightly
Is that your case?
Yes, it is my case.
Have we set you down for oral argument?
No, but it's been fully briefed.
Maybe we
It
should
was filed
defer.
mid-April.
Maybe we should defer this one until we get that one.
I mean,
Put them together.
We could put that onto September
Certainly,
and put them together.
certainly.
Why don't we do that?
I think that might make sense. I think that's a much better case for the court to address.
Where's the defendant in this case? Is he incarcerated?
Yes. Oh, I'm sorry.
Is he incarcerated?
Yes, he got a 3 to 5 sentence in 2004, so he's still serving.
Okay. Mr. Schneider, let me suggest to you, why don't you file a letter, assuming that we are entertaining the idea of deferring a decision in this case until September. It's fully briefed, Mr.
Yes.
Steinfeld?
Yes.
Until September, and then you can tell us why we shouldn't do that. Would that be fair? And you can reply to that, Mr. Steinfeld, if you choose to do so.
Thank you. I will. I'm sorry. There's been no reply brief filed yet in that case, but I expect there to be one very
Well,
soon.
September's plenty of
So
time.
it's not fully briefed.
Okay. Thank you.
Thank you very much.